Justice for Preston Lord that continues to bring people together in the pursuit of change. In the months following Preston's death, our community responded with acts of solidarity and remembrance. Marchers were held in his honor. Light the Night events were organized to raise awareness about teen violence. Attendees, united in grief and hope, wore orange, Preston's favorite color, to symbolize his spirit and the need to protect our youth. Throughout the Southeast Valley, orange ribbons appeared on trees and light poles, quiet yet unmistakable reminders of the life we lost and the work that remains. These ribbons told a story, one of heartbreak, but also resilience and resolve. In recognition of Preston's impact and the community's call for action, the City of Chandler proclaimed September 23rd, 2004, what would have been his 17th birthday, as Preston Lord Day. Every year on his birthday, we will honor his life and recommit to preventing the kind of violence that took him from us. Several laws have been passed in response, including one by the City of Chandler prohibiting the possession of brass knuckles by minors and the sale or furnishing of brass knuckles to a minor. Preston's law, which will increase the felony grade and punishment for anyone who participates in an assault with 2 or more accomplices, is under consideration with the Arizona State Legislature. In turning grief into action, Preston's family established Justice for Preston Lord, a nonprofit organization dedicated to breaking the cycle of teen violence and fostering a culture of hope, healing, and positivity among young people. The nonprofit works to raise awareness, promote education, and provide community resources. It offers access to counseling, educational programming on teen violence prevention, and free CPR training, a tribute to the 2 high school students who administered CPR to Preston in his final moments. Through Justice for Preston Lord, the family and others have spoken at city council meetings and have engaged in numerous events to benefit their communities. The outpouring of support from individuals and businesses has been spectacular. To further honor Preston's legacy, Preston's mother formed the Preston Lord Memorial Scholarship Fund to raise money and award scholarships to students of Preston School District, Combs Unified School District. Your Honor, the irony of our line of work is that we often never meet the individuals at the heart of our cases, yet we come to know them in deep personal ways. My husband and I never had the pleasure of meeting Preston, but everything we've learned tells us that he was the kind of person who would have offered his friendship, even to Mr. Hines. I want Mr. Hines to understand that. I hope that that truth weighs on the hearts of everyone here today. And while the defendant expressed remorse for the harm he has caused so many, his continued use of alcohol, even while incarcerated, raises serious concerns. Alcohol, among other things, was the underlying cause of the harm he inflicted. Genuine remorse must be paired with accountability and a commitment to change. And right now, that commitment is not evident. We ask that you follow the state's recommendation for 21 years. Thank you.
Thank you.
Thanks, Brian. And Your Honor, the next speaker will be Tony Rich, who is Preston Lord's grandfather.
Good afternoon, Your Honor.
Good afternoon, sir.
Tony Rich, Preston's grandpa.
All right, when you're ready.
I come here today to speak for myself as Preston's grandpa. On the morning of October 29th, 23, I received a call from my daughter that I needed to get to the hospital as my grandson Preston had been seriously hurt. I asked if he had been in an accident, and she told me no, that he had been jumped and beaten by a group of people and that had been seriously injured. I left immediately on a 4-hour drive to the valley, and when I arrived at the house, I saw the pumpkins that Preston, his sister, his mom, and my wife were supposed to be carving that day. This turned out to be the worst phone call I'd ever received. Of the 7 individuals that have been charged with Preston's murder on October 28th of 23, this is the first one that has admitted guilt. he had admittedly participated in the taking of life of a young man, by all accounts, from his teachers, coaches, friends, family, and everyone that knew him was going to be a leader and an asset to society. This is proved by his last moments of standing up for one of his friends. 3 weeks from now, on May 21st, my grandson Preston would have been graduating with his class at Combs High School at the top of its class. This individual knew within several days of the attack, by his own acknowledgement during his change of plea, that my grandson Preston Lord had died from the attack that he participated in. He has pled guilty to 3 other attacks, and all of the victims and their families deserve to know that he is serving time for each attack. I am asking the court that these sentences be served consecutively instead of concurrently. I'm also asking for the full 21 years that the state has recommended. His crocodile tears when he changed his plea from guilty for manslaughter and the other attacks really mean nothing to me or to his victims and their families. He is only remorseful for being caught and charged. On August 8th of 24, I was in attendance of a status hearing before Judge Cohen for those involved in Preston's case. I personally witnessed when Tyler Freeman was brought into the court for his status hearing having to do with the other cases that this person has now pleaded guilty to, that they were smirking and laughing at each other across the courtroom as this whole first-degree murder charge and the other attacks were just a joke to them. I brought this to the attention of Judge Cohen during the November 20th hearing when this individual trying to get his case remanded back to the grand jury. These cowards, some have called the Gilbert Goons, made a game of seeking out and attacking an innocent person for their own amusement. William Owen Hines, as part of this group, must be held accountable for his part in the act of taking my grandson Preston's life and the other attacks he has pled guilty to. Thanks.
Thank you, sir.
Thank you, Your Honor. And then the next speaker will be Melissa Sicante, Preston Lord's stepmother.
Okay.
Good afternoon. My name is Melissa Sicante, and I am Preston Lord's stepmother. Your Honor, there are no words that can truly capture the pain of losing our son, Preston. He was only 16 years old, just beginning his life, full of dreams, hopes, and a future that was stolen from him. Since the day that William Owen Hines participated in taking Preston's life, my world has been shattered beyond repair. Preston had a smile that could light up a room and a laugh that was contagious. He was a brother, a friend, and a young man with so much potential, but all of that was taken away. William Owen Hines, you took away his future, and you took away my ability to watch him grow into the incredible person that I knew he would become. The pain of his absence is unbearable. Every morning, I wake up with the crushing weight of knowing that I will never hear his voice, see him walk around the house, or have us sit on the sofa while we listen to what is going on in his life. I will never see him graduate, go to college, fall in love, or achieve his dreams. I will have to endure the emptiness, not only in my heart, but also in my husband's heart. I look at Nick, and I can see a piece of him that is missing.
Take your time.
A piece that can only never be replaced. The fact that he will never get to hug Preston, tell him how proud he is of him, or say I love you one last time destroys me. His sister will never have giggling moments between them of brotherly and sisterly bonding. She will never have nieces or nephews. She will never have her partner in life, her brother. Your actions have left an emptiness in my soul that will never heal. You have taken away Preston, and with it, you have stolen a part of my heart. No parent should ever have to bury their child. No family should have to endure this level of suffering. I want you to understand the magnitude of what you have done. I want you to feel the weight of the pain that you have caused, not just to me, but to everyone who loved Preston. I hope that every day for the rest of your life, you remember his name, his face, and the life you cut short. When you participated in Preston's murder, you not only took his life, you took his voice, but I will not let his voice be silenced. I will speak for the voiceless and demand justice for our son. You will not take away my right to stand here and speak on his behalf. While no sentence will ever bring our son back, I ask that the court impose the maximum punishment. Justice will never be enough, but it is the only thing left to fight for. I will grieve for our son every day for the rest of my life. I will carry this pain forever, and I pray that one day you truly understand the depth of the devastation that you have caused. Thank you.
Thank you, ma'am.
And Your Honor, the next to address the court will be Nick Lord, Preston's father.
Before we hear from Mr. Lord, could I speak with counsel briefly?
Sure.
And sir, come on up. I just need to. Okay. Sir, sorry to keep you waiting. When you're ready, go ahead.
Your Honor, my son Preston Lord was a bright, kind, and compassionate young man who brought joy to everyone around him. From an early age, he made me immensely proud to be his father. He loved his family deeply, cherished time with friends, and had a promising future ahead of him. Preston was not only an exceptional student, maintaining outstanding grades while serving on the student council, but he was also a dedicated athlete who played both basketball and golf. He had earned his driver's license and was embracing the freedom and excitement of his teenage years. His whole life was ahead of him. The tragic and senseless violence that took my son's life on October 28th, 2023, has devastated our family in ways words cannot fully capture. Our world has been shattered, and no parent should ever have to endure the pain of burying their child, especially under such horrific circumstances. The loss Preston has left an unimaginable void in our lives, one that can never be filled. As we stand here today, I have no words of forgiveness to offer William Owen Hines for the role he played in my son's death. The severity of the crime demands accountability, and I ask for the maximum sentence to reflect the gravity of his actions. Justice must be served not just to our family, but in Preston's memory and the community that has mourned this senseless act of violence. Thank you for allowing me to speak.
Thank you, sir.
Thanks, Nick. And Your Honor, the next speaker will be Autumn Curiel, Preston's mother.
Preston William Lord was my world, my buddy, my friend, my proudest accomplishment. He was ripped from my life because of senseless violence. If you knew Preston, you knew that he was the furthest thing from violent. And what happened to him was inconceivable. Preston was consistently committed to doing what was right. He had no enemies, and he was the last person to deserve such brutality inflicted upon him. The loss of Preston has dismantled my life, his sisters, his dad and stepmoms, his many friends, his grandparents, and many other whom he crossed paths with. Preston was a rare light in this world. He was a leader, not a follower, always helping others where he could, even if they were people he didn't know. Preston wasn't just my son, he was my heart, my best friend, and the light of my life. We were each other's biggest cheerleaders. He had the most thoughtful ear when it came to listening and talking about life. He always made sure to tell me how he did on a test or what grades he was getting. He was a responsible boy with high standards for himself. I raised Preston to achieve, to be kind, and to embrace a growth mindset. Now that he has been ripped away from my life, I long deeply for our conversations and to spend time with him. He had a rare gift for listening and for guiding others to make good decisions. He gave support to his friends without pause. Several of his friends' parents have reached out to tell me how much he has impacted their lives and helped them through tough times. Preston was witty and handsome. I remember looking at him one day and thinking, wow, you are just a cool kid. He was happy as he was. He had his own style, and he was funny. He was not interested in partying and did not get into trouble. I told him almost daily how proud of him I was, and he would smile humbly and sometimes give me a hug. Preston was always an easy kid and made me so proud from the beginning. From his birth to getting into kindergarten early as a boy, which is pretty unheard of with social and emotional skills, and throughout the rest of his schooling. He was considerate and respectful of his teammates and peers. His mind was so special and bright. He'd tackle math problems I couldn't even wrap my head around, and watching him excel made me so proud. He was chill and content, always calm during the hard times. We had wonderful times together as a family. Theme parks, playing football on the beaches in California, sports practices and games, holidays and movies. We were the three musketeers just doing life together. These times will never be the same without Preston. There will always be a void. Preston was raised to be an exceptional young man, and now the world will never get to know him. He has been robbed of his most beautiful life, and it was taken maliciously, extinguished as if it held no value. An unthinkable act which the defendant is responsible for. Preston meant so much to so many, and none of this was considered as he was being beaten to death and left in the road to die. If I could go back and rewrite the chapter of this book of life and what my family has dealt with, there are so many questions, so many what ifs. The conversations Preston and I had in weeks prior, I was talking to him in the kitchen and happy that my 16-year-old son was engaging with me openly about myself going to parties when I was younger. We laughed and joked, connecting mom and son. Never in my right mind did I fathom something like this could happen to him. I followed him religiously on Life 360 and lived in a safe community. I recently shared with Preston that it gave me comfort to raise him in such a safe area. The defendant, along with others, came into my territory. In a familiar neighborhood, my son always felt safe and stole that safety and security from us. He stole a promise I kept to my son to always keep him safe. We are now forced to live an unrecognizable life without Preston. He attended his first party, happy and carefree and hanging out with his friends, and then never came home. I have been robbed of my main purpose in life, being Preston's mom. There will never be a love greater than the love I have for my son. As far as the loss my daughter has experienced by losing her little brother, this I will never comprehend fully. To see her pain and loss for him in her eyes is just an added layer to our family's grief. When she moved out in July 2023, headed to college, Preston got up early and helped her pack up the car. He was the most doting, caring brother. He looked at her with pride and awe, like he was glimpsing his own future. He loved his sister more than anything. He respected her and looked up to her more than anyone in this world. The bond the two of them shared was unwavering, built on love and trust. Now she and I pretend to be strong for one another. Preston's absence serves as a constant reminder of our pain. I was only able to spend a few months with Preston after his sister went to college. These times were filled with so much closeness and bonding between the two of us. I will cherish them in my heart for eternity. We had pizza on Wednesdays, golf cart rides, golf practice, and driving lessons. Preston reached milestones, and we shared so many special moments. I still remember the night of his junior homecoming, which was also his 16th birthday, September 23rd, 2023. He came into my room, laid on my bed, and told me it was one of the best days he'd ever had. Little did I know that over a month later, his precious, most beautiful life would be taken. One day I had a purpose to be a mom of two wonderful kids, and the next day I was an empty nester. One day I had a happy and healthy 16-year-old son, and the next day I saw him lifeless in a hospital bed. One day I was helping Preston get ready for homecoming, picking out his tie with excitement, and the next I was choosing the one that he would be buried in. No parent should ever have to endure this. I loved watching my son Preston on the basketball court, hooping, guarding, and pushing himself to improve. I loved playing horse, pig, and 1v1 with him in the driveway. I can still hear his basketball sneakers squeaking on the court and his ball hitting the backboard. Preston was a quiet, natural leader. He didn't chase the crowd. He didn't have to. He was headed towards a vibrant life full of promises, including a future college career, having his own family, and so much more left unknown. Those dreams have all been wiped away. I will never know the grandchildren he would have given me. His sister's children will never know their witty, smart, and loving Uncle Preston, or to be able to play with their cousins. I've never seen anyone connect with children the way Preston did. He had such a natural, gentle gift when it came to playing with kids. The impact of losing Preston has been relentlessly devastating. His sister fights to succeed in college, even through unbearable grief. His friends have shared their own struggles with sleep and the ability to manage their emotions. I have lost my identity as his mother and continue to struggle to keep going, even just to put one foot in front of the other. The pain is deep, constant, and overwhelming. To say that Preston is missed doesn't capture the depth of the hole in our hearts that remains forever. The world feels colorless without him in it. It's dull, sometimes senseless, and everyday time moves forward while it feels like I'm standing still in October of 2023. The day after Preston was attacked, we were set to carve pumpkins and eat chili as a family. This tradition never came to fruition. Preston's favorite season was fall because it was his birthday in September. I would decorate at the very start of the month so he could be surrounded by the decor. Now fall and Halloween both torment me. It reminds me of the sign my neighbors had to put on my door to explain to trick-or-treaters that we had a family emergency and that no one would be home. During what should have been a fun, lighthearted time, our family was in the hospital watching our beloved boy fight for his life. The night we got the call that Preston had been attacked, and I was told that he was beaten so badly that someone had to perform CPR to try to save him, my entire world shattered. I raced to Chandler Regional Hospital while pleading with the Uber driver to go faster as panic turned into shock. When we arrived, they took us into a little room. Immediately, by observing the look on my sister-in-law's face, who was a nurse, I knew this was the kind of room that no family ever wants to be brought into. The doctor explained due to the severities of his injuries, Preston would be air vac to Phoenix Children's Hospital. The next days were grueling with agony. I remember the hospital staff having us put up pictures of Preston and helping his sister make necklaces in distraction. We couldn't eat, and his dad slept on the floor. In my heart, I knew my son was already gone. For 9 months, I carried him. A lifetime, I loved him, and far too soon, I was forced to say goodbye to him. I laid his pig, his treasured stuffed animal that one of our dogs had chewed up that he still loved, next to him, knowing that he was fading from us. When they gave us the news that he could no longer hang on, that day was the first day I stopped believing, and I was forced to leave his side. This day would change my family's lives forever. Watching the color leave Preston's beautiful face didn't feel real. It still doesn't. The memory won't let me go. The idea that this defendant could carry out such a cruel and meaningless act on someone so undeserving as my son will disturb me forever, leaving me broken. Preston's last moments in the hospital will forever be etched in my memory. Seeing him in the condition he was in was my worst nightmare. I brushed the hair out of his face, but quickly put it back, because that's the way that he liked to wear it. I kissed and traced every ounce of his face so I could hold on to every detail, so afraid of ever forgetting. I replay it over and over in my mind. I climbed into the hospital bed and held him for as long as I could. I dream of the sweet boy riding beside me in the golf cart, the upbeat young man walking across the stage at academic ceremonies, the wonderful, caring teammate calling plays in basketball, and the person so many turn to for strength. Preston gave so much and expected so little. In the weeks and months following my son's death, I lived in fear and consuming grief while remaining hidden from the world. We didn't know who had done this to him. We didn't know if they would hurt someone else. We had no answers, only pain, shock, and the agonizing silence of waiting. Waiting for justice, waiting for accountability, and waiting for the truth. We waited because nobody would come forward to admit what they had done to my son, including the defendant. And many others were bullied into silence. I was paralyzed, sleepless, hypervigilant, lost in disbelief that this was now my life. I didn't want or know how to live without my son. Preston was always the person who would reach out to help someone, no matter what their situation. As a mother, I want the defendant to know that his actions were callous, depraved, and heartless. Every part of me aches because the defendant had a choice, and he chose wrong over right. His actions show he chose to have no regard for human life. I've spent my adult life in a career supporting and helping young people struggling with social and emotional and behavioral challenges, and thus always taught Preston to lend a helping hand. You never know what somebody might be dealing with or going through. My son's kindness and willingness to help anyone in need far extended even to the it would have far extended even to the defendant if given the opportunity. Preston would have been his friend if he needed one. Each time we must speak about our loss, we are re-traumatized. Multiple people beating on one person is disgusting and cowardly. Imagining what Preston was thinking and enduring, and this cruelty shatters my heart, spirit, and clouds my sense of the world. The defendant acted without remorse, showing no regard for Preston's beautiful life or who his family was. The defendant deserves to be accountable to the highest degree and maximum sentence of 21 years for the magnitude of the incredible loss we have all suffered and the extreme light that he has diminished in this world. He deserves to be held fully accountable for the ongoing pain that he has inflicted upon our family and the community. The pain doesn't lessen, it deepens. Preston was an exceptional, rare human being with a kind, giving heart, a promising future, and a huge network of friends who loved him. He was an inspiration to so many, and his absence has left a hole that will never be filled. This is from something I wrote about Preston. Preston was our rainbow, steady, patient, and full of life. I love you always and forever, my beautiful boy, PL5.
Thank you, Autumn. Your Honor, the family of Preston Lord has provided a video, a memorial video that, with the court's permission, we would like to play at this time.
All right, thank you.
Your Honor, you've now heard about what the Zazek family went through. You've heard from Preston Lord's family. And it's clear that this is not an easy day. And in fairness, we know that it's not going to be an easy day for anybody in the courtroom. The defendant is 19 years old, and he's here today for crimes that he committed before he turned 18. And we recognize coming into this that the court is going to look at his age as a mitigating factor. That is what the law says, and it usually makes sense because immaturity and impulsivity often play a role in crimes that are committed by 17-year-olds. So why then is the state asking for the maximum term under the plea agreements? And the answer is simple. It's because when you look at the totality of what has occurred here, and you look at the whole picture, this is not about immaturity. This was not a few isolated incidents of seeking attention and getting carried away with friends. It may have started out that way, but that is not what brings us into this courtroom today. We appreciate the context that the defense provided for what was going on in the life of William Hines in his teens and early teens. And it's clear that Mr. Hines has had problems with alcohol and drugs going back at least to 2021 when he was around 14 or 15 years old. So before his involvement in the legal system, there was that struggle. There had already been some interventions. There had already been some treatment that was described in the materials provided by the defense. But the story of why we're here today begins in November of 2022. William Hines turned 17 on November 26th of 2022. But 2 weeks before that, he got caught shoplifting. It was a misdemeanor. Police ended up at his house. They talked to him. They talked to his father. And it was clear that the matter was going to get referred to juvenile court. And that certainly can be an example of simple immaturity. However, I brought it out in the sentencing recommendation because it was a chance. It was something that could have been a wake-up call. This was, again, just before his 17th birthday. Apparently, though, it had no effect on him because less than 2 weeks later, he was then involved in a group attack. And that's that first aggravated assault case that you have, the Class 6. And I want to be very clear about this. When a group swarms, blitzes, and attacks a victim, even after the victim is on the ground, that is not a fight. That is not getting into a fight at a party. That is not mutual combat. That is a crime. And it's the kind of thing that he and his friends did multiple times. This overlapping group that you've heard about, the guys who became known as the Gilbert Goons. Now, on that incident, one would have hoped that the next day, when William sobered up and had a chance to think about what it is that he took part in the night before, he would have resolved right there and then that he is going to change his life, because it should have been another wake-up call, a wake-up call that he's on the wrong track. And that's especially true in that case because, as you know from the facts in the pre-sentence report, his friend had used brass knuckles on the victim that they targeted. So once learning, if he already didn't know when it was happening, again, that is something that really should have changed his course. But again, nothing about that experience changed him. And we know that because it was just days later. On December 2nd of 2022, again, he's on video, and this time he's punching another kid from behind. And when you look at the video, it's 9 times punching a kid while the kid was already being attacked by other accomplices. What you see on that video, and that was one of the videos that was submitted to the court, what you see there is not immaturity. It's something else. It's a lot more than just adolescent recklessness. Later that same month, the defendant is again.
That one. Yep.
I'll wait for that to get muted. Okay. So later that same month, the defendant is again committing a crime. And this time, it involves a safe that had thousands of dollars in cash. It had been stolen, it appears, by his friends. It had other valuable items, and it was put into the vehicle that William was driving. And the vehicle he was driving was his mother's vehicle, so essentially he helped facilitate the theft. He'd be an accomplice. As you know, it was adjudicated in juvenile court as a facilitation to commit theft. What's important, though, for the chronology and for this court's determination of what's going on here is he gets arrested for his role in that crime. Again, it happens at the end of December, but the police show up and they arrest him in March of 2023. So again, we have another critical point, another wake-up call that we now know has no effect on him. Before he gets placed on probation for that crime, he's driving drunk and he smashes his dad's truck into Benjamin. So the defendant was there. He was on scene when another human being had to be removed from the vehicle that the defendant had plowed into, and then that victim had to get rushed in an ambulance to the hospital. He knew he did that. He knew he came close to causing another human being's death. And still, it wasn't enough to change. So it was a month after that collision, so now we're in August of 2023. That's when he gets put on probation for the case involving the stolen safe. So let's kind of take a break and see where we're at. It's August of 2023. He had been caught by police for the misdemeanor shoplifting. He got caught by police for his involvement in the case with the stolen safe. He's now been arrested for this drunken collision that he caused in July. And at this point, there's also been some previous interventions that were discussed in the defense materials. So August of 2023, he's now placed on probation. If there was ever a time in William Hines' life where he really needed to be turning things around and be on his best behavior, it is at that point going forward from August of 2023. But based on what is contained in the pre-sentence report, it appears that he just didn't care. Apparently, he hadn't paid a single dollar in the restitution for his juvenile case. He had reported no progress on obtaining his GED, and he had failed to complete his community service hours. So by October 28th of 2023, less than 3 months into his probation, he hasn't changed at all. He's still part of the same group of bullies. He's still drinking. And then there's Preston Lord, only 16 years old, who didn't do anything wrong at all. He's just trying to enjoy a Halloween party with his friends, something that should have been a good, memorable high school experience. Now, by the time William Hines shows up at that Halloween party, being an alcoholic and being an adolescent is no longer a persuasive mitigating factor. Drunk or not, William Hines made a choice. He chose to join in with his group of friends, chase down and beat Preston. The defendant knew that they had just beat this kid unconscious on the asphalt. Yet a few hours later, while Preston is dying in the hospital, the defendant continues to party like nothing ever happened. Preston's in the hospital. William Hines continues to party. And you have the videos that were submitted to the court when he continues to drive drunk, even though 4 months earlier, he nearly killed somebody doing the same thing. And when you're watching those videos, the thought should go through anybody's mind that either he or his friends who are in the car with him or a family driving home could be absolutely wiped out because he either cannot or he will not stop drinking. He will not stop getting drunk. And then within a few days, he knows. He knows that the boy that he and his friends attacked had died. This would be the ultimate wake-up call for any reasonable person, even an adolescent. And now, here we are today. Even after being arrested, even after being thrown in jail, he still cannot stop himself from drinking. And this time, as you have from the calls that the state submitted to you, we're talking about the homemade jail alcohol, known as hooch. So even in the most controlled of environments, William Hines still can't control himself. And I want to be clear about this. His addiction does not make him an inherently bad person. We're not saying it makes him an inherently cruel person. That is not what we're saying. But it does make him a dangerous person, a danger to himself and a danger to the public. So why then are we recommending the maximum term? Given these facts, this accumulation of circumstances, what are we supposed to do now? Yes, the defendant was 17 years old. On the other hand, Preston Lord was younger. He was 16 years old when his entire life was taken. And it is also true that William Hines is not the only person responsible for Preston Lord's death. We know that. But when you acknowledge that, there is a corresponding aggravating factor there, and that is the presence of accomplices. In fact, it is the group criminality that led to Preston's death. It was the same type of mentality that was on display on October 28th that you also see in those two other aggravated assault cases that he's now pled guilty to. So now, probably one of the hardest things to judge in this case is the issue of remorse. For example, in the vehicular case, the body camera footage from the July crash, it shows the defendant on the scene as the police arrive, and it's clear that he is very upset. And there are two things that William Hines is expressing emotion about. And in fairness, one of them is that he is asking about whether the other driver is okay, which would be Benjamin. But then the problem is that alongside of that, in the same sort of, I don't know if it's within 5 or 10 minutes or around or even less, he's expressing a lot of emotion about the fact that it is his dad's truck and his dad is strict and his parents are going to be so mad. So it's hard to judge what level of remorse and empathy William Hines has. Those who evaluated William Hines that are referred to in the defense materials, they clearly believe that he is remorseful for those that he harmed. And when the defendant was in the courtroom at the time that he did his change of plea, he read a letter and he seemed sincere when he expressed remorse. Of course, since that time, we realize there is a huge, huge problem with that expression of remorse. And the reason is because the same letter also included an expression of being sober for a significant period of time, as well as what sounded like a very sincere commitment to staying sober. And we now know that that part, which the state submits as a very important component of the statement that he made to the court, that part was not true. Now, what we hear in the jail calls that contradicts it, the question arises, does that invalidate either all or some of his expressions of remorse? That's something that the court will have to consider. But there is a larger point to be made here. Whatever level of remorse William Hines might have, it wasn't enough to change him. We know how powerful an alcohol or a drug addiction can be, and we know that in many cases in the criminal justice system, it can be a mitigating factor. But in the case of William Hines, it should not, at this point, be a mitigating factor. And part of the reason is because we now have all of these warning signs. We have all of these red flags that we have to take note of. We're on notice of how police at his doorstep, that's not going to be enough for him to change. We're on notice that severely injuring someone in a car crash, that was not enough to change him. We're on notice that being on probation is not enough to change him. We're on notice that even the knowledge of Preston Lord's death, and then even being locked up in jail, nothing is causing the change that needs to happen. And based on the jail calls that we submitted to the court, he does not intend to stop the alcohol, and it sounds like also some substance abuse. And if he doesn't intend to stop it, which is the evidence that we're now considering, then that is precisely what renders him so dangerous when he's back out in the community. So what we're left with is a young man who has left a path of destruction behind him, and he is just not changing course. So in the case ending in 6240, that's the vehicular case, Benjamin Zazik suffered very serious physical harm. And that is an aggravating factor that is far heavier than any mitigation that exists in this case. As you heard, 4 months of memory loss. It's a gap, it's gone. You heard about how he had to learn how to speak again, learn how to walk. That aggravating factor is entitled to very great weight. And it's especially true, Your Honor, when you think about how hard the recovery was, not just for Benjamin, but for his family. It's clear that it was not just... It's clear, Your Honor, that Benjamin was not the only one who felt the impact of that crash. And what his mother described in court today is truly extraordinary. Then, in the case ending 6528, Preston Lord's case, the emotional anguish of Preston Lord's family by itself outweighs all of the mitigation. And I would point out that that emotional harm, you can almost see it, that it has a physical component to it. The effect that it has on them, the effect I think you heard about sleep, all of that, it is not just the emotional pain, it's almost a physical pain. The family has been coming to court date after court date, whether they appear in person or whether they appear virtually. Every single time, it's reopening that wound. And that memorial video that we all just watched, that only scratches the surface of what the family has lost, because that video cannot show the future. It can't show what Preston was going to become. There's also, Your Honor, the presence of accomplices as an aggravating factor in this case. And this is very important because it represents what the defendant and his friends were doing. They attack in numbers. They attack in numbers. So the presence of accomplices is another very important aggravating factor. So, Your Honor, however you choose to fashion the prison sentences today, whether it's concurrent, whether it's consecutive, we are asking that you impose the sentence that will provide the most deterrence. We're asking that you provide the sentence that will provide the most protection for the community and one that punishes the defendant appropriately for the totality of harm that he has caused. And for those reasons, we recommend the maximum total term of 21 years in prison, followed by the probation tails in the 2 aggravated assault Class 6 cases. Thank you.
All right. Thank you, Mr. Green. All right.
Judge, for the defense, we have 2 speakers before I plan to make my presentation. Our first speaker is going to be Owen's mother, Laura Hines.
Thank you.
I'm Laura Hines, and Owen is my son. When Owen was born, he was my miracle baby. Bringing him into the world was not easy. I suffered 3 miscarriages and years of infertility tests and treatment. We had almost given up hope. When he was born, healthy, perfect, and beautiful, we were overjoyed. Owen has always been a very sensitive, loving, affectionate person. If he was sitting next to one of us on the couch watching TV, he would have to be cuddling or at least have a foot on my lap. He loved making friends and his music together and jamboree classes. When he was 6, he started flag football, and that became a huge part of his life. He loved being on a team. He loved his teammates and coaches. It was something he excelled at. After struggling in school with severe ADHD, anxiety, and depression, and it gave him confidence and community. There were many events that seemed to set Owen on the wrong path. Football was taken away by a bad concussion his freshman year. COVID lockdown had a negative effect on his schoolwork and his mental health. Our divorce in 2022 was hard for him. On April 3rd, 2023, we lost my dad after a heart attack. Losing Papa devastated all of us. Papa was Owen's #1 babysitter, one of his biggest cheerleaders at all of his football games, and someone who was always there for Owen. I don't think any of us have been the same since. We were grieving, and I was struggling to deal with my own grief and depression while adjusting to working full-time for the first time since my kids were born, which left me physically and emotionally exhausted. It ended up being the worst year of our lives for many reasons. While he has been in jail, I have seen so much growth and maturity in my son. I'm always amazed at how his attitude stays positive. He has found a strong relationship with God, which I think helps. He is reading the Bible and praying and listening to sermons online. He has been reading self-improvement books and journaling to help heal his past hurts and get past his shame caused by his actions. He is determined to become a man we can be proud of and to never repeat the actions that brought us to this place. We can't change the horrible events that took place in 2023 as much as I wish we could, but we as a family are going to do everything we can to help Owen in his growth and recovery. As his mother, I will continue to be his emotional support person. I will encourage him and whatever I can do to see that he follows through with his plans to earn his GED, learn as many trades as he can to be a productive citizen, and to continue his journey with Christianity and healing. I will encourage him to participate in programs like Celebrate Recovery while he is away, and even attend with him when he gets home. His recovery and sobriety will be a lifelong focus for us. I know that Owen hurts badly from the pain he has caused. I also know who he is inside his heart and soul. His actions do not reflect his heart. The real Owen is not the teen who made a terrible choice to drive under the influence, causing the accident that injured Benjamin. Owen is the young man who ran from his damaged truck to the other car and was frantically yelling for someone to help Ben while trying to open the door. Owen in his soul is not the person who kicked Preston. He is the person who immediately stopped and was begging the others to stop. He is the young man who is living with his remorse, shame, and pain. He is the young man who is actively and determinedly seeking ways to never repeat the mistakes of his past. He wants to turn his life around. To Ben and the Zazik family, I am so sorry for the pain and fear that you had to suffer. I prayed for Ben and was so grateful when I heard he was recovering. I hope the future brings you happiness and health. To the Lord family, there will never be the right words to convey how deeply I hurt for you. You and your beautiful son, Preston, will continue to be on my mind and in my prayers for the rest of my life. I am so sorry for all that you've had to endure, and I pray for peace and healing for you all. Thank you.
Thank you, ma'am.
Judge, our next speaker is Owen's father, William Hines.
Your Honor.
Hello, sir.
Thank you. I'm reading this for the simple reason that I do not want to misspeak or forget to say anything that is important to me. So if it sounds scripted, that's not my intention. The position I find myself in is very difficult, as I love Owen and Jack, both my boys, more than anything in the world. For the reasons we are here today, the combination of being upset, horrified, embarrassed, and dismayed all at the same time, while also feeling compelled to help my oldest son, Owen, as much as I can, is a true duality. To the families affected by Owen's actions, I would like to apologize. To Benjamin and his family, I am very sorry for Owen's decisions that night of the car accident. Please accept my sincere apologies. To Preston's family, I don't even know how to begin to express our apologies. If I could say sorry 1,000 times, I would. On behalf of our entire family, I offer our sincerest apologies and sincerest condolences. Your Honor, although Owen had veered off course over the last few years and made huge mistakes, he is taking responsibility for what he has done. As his father, I can explicitly say that he is a compassionate and remorseful human being. Owen has a big heart, and he does feel very deeply. I've seen this time and time again throughout his life. One example I would like to share was during a football game in high school. Owen had made a tackle, and a boy was injured. The following day, I asked Owen if he had heard anything about the boy, and he said, "Oh yeah, I figured out who he was. I reached out, instant messaged him, make sure he was okay." The gesture was all Owen's action. As his father, I can attest to this sensitive and compassionate side of Owen throughout his years. Again, that's just one example. Your Honor, Owen wants to take responsibility for what he has done to others. I think he is saying, I don't know how I got here. I don't like where I've been. I'd like to fix it and make positive changes within myself. Regardless, he is taking responsibility for his actions and wanting to make amends. I'd like to close my statement today by saying that it is not lost on me for 1 minute that the Lord family is going to continue to come down here to the courts and go through these hearings week after week and month after month. It is absolutely heart-wrenching, and I wish them Godspeed. Thank you.
Thank you, sir.
And Judge, I will just need a minute to set up.
Okay.
I think you just need the HDMI cord. I think you just need the HDMI cord.
Judge, anytime that we're at a sentencing, it always means that something bad has happened. And you've presided over many, many cases, and you know that there's a scale as to where we're at a sentencing. And this is clearly on the high end. What's happened to these families today is absolutely terrible and horrific. We're learning still today how Owen's actions over 2022 and 2023 have affected these families, and it clearly has a lasting impact on them. But by the same token, we are also at a sentencing because Owen stepped up and took responsibility for his actions and the part that he played in all of this and why we're here today. He pleaded guilty, and he's the first one to do so. And I think it's worth spending some time to talk about the unique circumstances of how we got here as well and how he changed his plea. We did a settlement conference with Your Honor, and you learned about the plea offer before Owen did. Owen learned about that plea offer, and 2 hours later, he was in court and accepted and entered it. Those circumstances demonstrate overt willingness to take responsibility. There was no hesitation on Owen's part. He stepped up and he took responsibility. And there are topics that we need to discuss in this case that are at the forefront. It's important that we spend time talking about them, but I want to make clear that when I talk about these are not an excuse, and it in no way justifies Owen's actions, and it certainly does not minimize the harm of the consequences of what he's done. But it is context, because we don't arrive here in a vacuum. An 18-year-old doesn't just face murder charges. A 19-year-old doesn't just get sentenced for those same murder charges. Owen was 16 or 17 years old at either time of all of these offenses. And that has an impact in these cases. Teenagers are different. It's biological fact that teenage brains, adolescent brains, and circuitry and anatomy are tilted towards intensity, emotion, lack of self-regulation, and recklessness. And those things happen, and I don't want to get too into the weeds into this, but frankly, what's going on is that teenagers, their prefrontal cortexes are underdeveloped. The prefrontal cortex is the part of the brain that makes an adult an adult. It's in charge of executive functioning. While at the same time, the subcortical region of the brain, the animal part of the brain, is highly developed, highly primed for emotion and reward processing. And so what does that look like in the real world for someone Owen's age? Well, it means that they lack future orientation. They don't consider the consequences of their actions, even though it's hitting them in the face. It sounds like 5 times in this case. It makes them more vulnerable to peer influence, especially negative peer influence, which again is happening in this case at least 3 times. Teens are also less risk averse. They're primed to seek the reward and not the consequences. And the connections between Owen's cases and all of the uncontroverted scientific evidence about juveniles' brains are demonstrated in all of Owen's cases. It bears the hallmarks of immaturity, risk-taking, impulsiveness, and vulnerability to peer influence. At the settlement conference, we discussed how Owen, again, working with a group, being in a group, acting as a follower, jumps into these fights. And the reason why is his nuclear family life is falling apart. He's experiencing tough losses, and he's looking for acceptance in all of the wrong places. And he found it in a group that likes to fight, likes to drink, likes to use drugs. And that's how we end up here. And I can understand a tendency or an inclination to want to roll your eyes at this and say that this is not an explanation. Owen is something different. And I can understand that. I think that when we look back at our teenage selves, or maybe we think of a teen that we know now, and it sounds like someone like Preston would never be in Owen's shoes, would never be in this situation, facing a murder charge, a terrible car accident case, and other group assault cases. But I think if we really take a hard look at our adolescent years, I think there are times when we were growing up, things could have gone seriously wrong, if not for a near miss, dumb luck, or divine providence. And I think it's important to recognize that in some ways, if we came out of our teenage years unscathed, we're incredibly lucky. And I think we are also incredibly lucky for some of the older folks in the room that, frankly, we didn't record everything and put it on Snapchat. But nonetheless, immaturity is not the only thing that's going on in Owen's cases. We also have someone who is using substances at the same time. And of course, experimenting as a teen is normal, but that's not what we have here. And Mr. Green discussed it beforehand, but we have someone who was drinking near daily at age 15. That is someone who is an alcoholic. And I think it shows that something is deeply wrong, but it also raises the concern that this is also something that's highly complex, and sometimes it might need more treatment than we think. What's happening in Owen's case and his alcohol use is not normal. This is what we have here. And the state showed you these photographs in their sentencing memo, and these are screenshots from some of the videos that they sent you. And they're telling you that this is a person who was a danger to society because of his addiction. I see a teenager who doesn't know what to do, who's self-medicating because of trauma and anxiety, blunting those emotions, and doesn't know what to do. And that's compounded by his immaturity. And not to mention the profound effects that drinking alcohol has on a juvenile's brain. It's very complex, but to put it simply, it's like pressing the pause button. But it also has effects on memory and cognition, which also could potentially play in a part why Owen is just not getting the point yet. But I look at this, and it's sad, and it's embarrassing, but also this is someone who can be treated and still deserves treatment. And that's better for our society. And like life, you know, this is not all black and white. There are shades of gray. And that's the same for Owen. It's not black and white. There are some good things and there are some bad things. And one big thing about him is that Owen came forward on November 1st, 2023. That was 2 days after Preston Lord was taken off life support. And I think that this might be an inconvenient fact for the Queen Creek Police Department. Sergeant Uribe wrote a letter in the pre-sentence report. I've done homicide cases, and it's not, I wouldn't say it's rare, but you know, it's not something that's usually done in a case where a case agent is writing something. But what she writes in her letter is that instead of making the conscious choice to contact detectives, it took the detectives knocking on Owen's door with a search warrant before he provided any information. Queen Creek Police Department's own reports in this case demonstrate that that's just not true. Owen and his family on November 1st, 2023 had a meeting with his juvenile probation officer, and they told his probation officer that he was at that party and he was drinking, knowing that that would be a violation of his probation alone, but he also said that he had information. His juvenile probation officer called the Queen Creek Police Department that same day and left a message, and that redacted part in this, that's Owen's phone number so that the Queen Creek Police Department could call Owen. Again, that same day, Owen's father, William, who you heard from, he himself called the Queen Creek Police Department to facilitate his son giving information to the police department. At the time, Owen is still 17, and many of the juvenile witnesses in this cases had a parent there to referee with the police. So just because Owen didn't call himself, he and his family are trying to come forward and to provide information. And so when the sergeant is writing that Owen's actions and his silence can't be ignored, well, the natural corollary to that as well is that him coming forward likewise can also not be ignored. We also need to address the elephant in the room, which is Owen's jails calls. And the state's argument, and I can understand where they're coming from, is that Owen isn't taking this seriously. He's not changed. What is it going to take? He's not dedicated to sobriety. And it also undercuts his remorse. But the 7 jail calls that they gave you don't define who Owen is. They don't define his range of emotions, and they also do not define his remorse. Owen is still genuinely remorseful about his terrible actions that forced us into a sentencing today. And Mr. Green aptly put, right, that you would think that getting arrested, being placed on probation, going to court, being placed in jail, going to prison, you would hope that that would be enough. But jail, prison, arresting somebody, unfortunately, it's not a magic wand. As much as we would want those things to be, those things alone don't fix people, and they don't fix their problems. And so Owen is in jail for 14 months, something that no one wants to do, wants to be in. He's realizing very early on that he's going to prison in these cases. And that's terrifying. That's terrifying for adults, but it's terrifying for an 18 and a 19-year-old whose brain is just like a 16 or a 17-year-old. And so what is he doing? He's talking to his friends on the phone, and he's trying to impress them, these same people who still got him into these situations. He's coping with the trauma. He's puffing his chest. And frankly, that's a lot from what he's learning in his pod. Owen is held in a protective custody pod, and he's housed with much older offenders. And these offenders are facing the death penalty. These are also offenders who are brought back from prison to jail because they're committing crimes in prison. And unfortunately, that is the culture of the pod. You just can't cry in jail. You can't do those things. It's also, in a sense, it's disingenuous as well to say that he's not remorseful, not truly remorseful. Because when you pick 7 calls, you can create a narrative, any narrative. If I just showed you a couple of calls and said, you know, he was a perfect angel baby, that wouldn't be the true story because there's a duality to this person. But there are some calls that the state didn't direct you to when Owen is on the phone talking.
I've been having a rough time at night, though.
Have you?
Yeah.
Because you're alone?
No, it's because I feel guilty about a lot of stuff. I was a very stubborn motherfucker, and it took this, and it took all of this to get out of that stubbornness, and it should not have took this. It should have I should have listened to all the warning signs. The first time I got arrested should have been enough. And no, I didn't listen. Then I got in a car accident. That should have been enough. No, I didn't listen. And now I'm in jail for this, which is so fucked up. It should not have took all of that.
And there's no sugarcoating it, Judge, that these calls, the ones that the state brought to your attention, they're difficult to listen to. And frankly, I would want someone to do better, but they don't change the fact that Owen is a minimal participant in the homicide case. It also doesn't change the fact that he came forward 2 days after Preston Lord passed away and died, where he tried to give information. And it also doesn't change that on November 7th, he admitted his guilt and his involvement to a detective. And it also doesn't change the fact that he is the first person to take responsibility in this case and plead guilty. The state is asking for 21 years. And I want to address the aggravating factors that the state has put on the record. The first is the harm to the victims, which is clear and it is weighty and it cannot be understated. There's also the presence of an accomplice in at least 3 out of 4 of Owen's cases. But these aggravating factors are going to be applicable to each and every defendant who is in that Preston Lord case. Is the state going to recommend the maximum for everybody? I don't know, because that's going to be in the future when those people either accept a plea agreement or they go to trial. But what we have here is a sentencing, and you're going to have to decide, and I don't envy you, because Owen is the first one to go. But I can think of one differentiating factor from Owen from his other defendants, and that's his specific actions in each of these cases. So what did Owen do in these cases? And I do want to spend a little bit of time talking about it, but I don't want to go deep into the facts about this. But in the car accident case with Benjamin, what happened to him is terrible. But it was an unintentional injury. And he also stayed at the scene. In the aggravated assault cases, again, we have someone who is acting like a follower, and he's jumping into these fights after they've already started. He's not the one who's starting them. And thankfully, he's not the one who's using the weapons and the brass knuckles. And now let's get to the homicide case. In the state's sentencing recommendation, they said that the state and the defense disagree on the extent of Owen's conduct in that case. And that's fine. We can disagree about that. But the court should decline any sort of invitation to sentence Owen more harshly based on speculation, especially when we have evidence about what he did in this case. This is a screenshot from an interrogation that Owen participated in, or an interview that Owen participated in with Detective Shipman. During that interview, he told Detective Shipman that he kicked Preston Lord right after Preston Lord fell to the ground. He believed he kicked him in the leg, but he also fully realized it also could have been his stomach. He said he thought he kicked him once, but he also, the detective threw out, maybe you kicked him 3 times, and he agreed, and he said, it's possible that I kicked him 3 times. But he also said that he realized Preston Lord was unconscious right after he kicked him, and he stopped what he was doing, and he tried to stop others as well. And there's no evidence refuting what Owen said to the detective about what he did. In fact, we have corroborating evidence. We have Jack Woods saying that he heard someone yell, "He's out." And then we have Luke Odell, who says that Owen was freaking out after this happened. And he said, I don't know why, he told the detectives that Owen said, I don't know why everyone was kicking his head. I only kicked him in the stomach. That corroborates what Owen's involvement is in the Preston Lord case. From a public safety standpoint, 21 years is also excessive. One of the hardest things to talk about in homicide sentencings, and it's a fact that just cannot be ignored, and it's something that is routinely talked about, is that the defendant, same thing with Owen, he's going to be able to walk out of prison one day when Preston is no longer with us and won't have that opportunity. And I don't mean to sound callous about this, but because Owen is young and because he will get out of prison, the court does have to carefully consider the length of the prison sentence in this case. A big reason why is because even under the shortest sentence available under this plea, Owen's going to be at least 26 years old when he's released. And 26 years is an important number. The reason for that is because the people who committed crimes as juveniles, that's the age, 25, 26, when they figure things out and they get their lives together. And so potentially maybe some additional time is warranted from the court's perspective, but there also needs to be a realization that there's a delicate balance, because unduly long prison sentences could potentially increase Owen's risk of being back before this court again. It's going to be less time for him to find a job and to do those things, like start a family. I know that Preston won't be able to do those things, but those are important things for Owen and our community, because those are the reasons why people don't commit crimes, is because they have jobs, they have families, these pro-social roles. And frankly, the longer that Owen is in prison, it makes it less likely that he can do those things, and no one wants to see him back here. The other factor is deterrence. And what deterrence is, it's not deterrence for the person, but it's also general deterrence. The idea is that if you sentence someone harshly, it sends a message to other people, don't do this same exact crime, because you're also going to be punished harshly. And I think the state and the defense are going to have some philosophical disagreements about that, but we can talk about the propriety and the effectiveness of that idea in Owen's sentence. And that's because, really the literature and studies have shown that general deterrence is not a super effective way to deter the public from committing the crime. And the reasons why are because, one, they have to know that they're going to get caught, but then also they need to know what the consequence or the punishment is going to be. And so when we think about juveniles who don't consider future consequences, are risk averse, they don't think they're going to get caught, they don't know the consequences, it's not going to be very effective to deter other juveniles from committing these certain crimes, because they're not thinking about what happens next. They just do, unfortunately. They just act the way that they act. And that's also true for serious crimes. Potentially, I think there are other ways that would be more effective, and I think it would have an immediate effect, something that might be within Queen Creek Police Department's purview and control. They might be able to increase policing, increase their presence in the area, which I think I have seen some recent news reporting that might be going on, at least in Gilbert, with officers in the schools and being there. But I think that increased presence could also serve a function for the kids to see, that the police are here and they're going to catch me. That has a bigger effect on reducing juvenile crime than throwing the book at Owen. The next thing that this court is going to have to decide is whether you're going to run the sentences in the aggravated assault car accident case and the homicide case, whether those are going to be concurrent or consecutive. We're asking for a concurrent sentence, and we have highlighted some factors that we believe support that sentence. In 3 out of the 4 cases, Owen pleaded up to the charge. He didn't get a reduction of his charge in each of those cases. For the aggravated assault cases, his pleas are harsher than usual in those cases. In typical defendants who are not, all in this East Valley teen violence problem, typically the offer would be a misdemeanor. In the aggravated assault case, which is the car accident, car collision case, that plea is also harsher than normal. Obviously, Ben suffered some very, very serious injuries. Even with serious injuries like that, prison is often inescapable in these sorts of cases, but we're definitely not pleading to a dangerous crime. It's typically non-dangerous, and the prison term is less. In that car accident case as well, there was a substantial civil settlement outside of court. And I don't mean that to mean that makes Benjamin whole or his family whole, and it doesn't mean that Owen does not deserve to be punished, but it separates him from others, because I'm sure when the court has provided or presided over other cases, you've seen cases where defendants have maimed victims and then they can't pay them back and they're just left in a lurch. Benjamin and his family deserve every penny from that civil settlement, but it's something that should be considered when we're talking about concurrent versus consecutive sentences. Additionally, and a fact that's not lost on Owen is that he pled to 2 dangerous offenses. And so for Owen, what happens if he commits a future serious offense? He's facing mandatory life imprisonment. And that's a huge motivator for him to change his behavior. But it also shows, too, that he's getting double punishment. He is, even with concurrent sentences. I want to conclude my remarks by talking about Owen's prospect for rehabilitation. And Owen he's an excellent prospect for rehabilitation. 2 big reasons why. One is that juveniles, for all of the time that I've really frankly spent ragging on them and all the ways that they act bad, they also have tremendous capacity for change. The other thing, too, is that most juvenile offenders, when they grow up, they just stop committing crime. And that's true even for juveniles who commit serious offenses just like Owen. And so he's probably going to follow the majority. The other thing is that Owen has tremendous support, tremendous family support. He comes from a good family with good people, and they tried to get him help. They tried to get him treatment, and it's not their fault that it didn't stick. But they, too, like Owen, are realizing the magnitude of his addiction and how he's going to have to deal with it for a lifetime. And they're committed to helping him with that, and they will support him when he's released. The big key for Owen is his sobriety. And the state has made that clear. And it's obvious that the key for Owen to not be back here is for him to be sober. And in that regard, while prison is not ideal, it's a lot better than jail. And the reason why is because there's a lot more programming and resources in prison. He'll be able to take classes, he can learn a trade, do therapy. Those things are not available in jail. And so that's important because it will help educate Owen, who is still ignorant about his addiction, but it also gives him reasons to choose sobriety. And Judge, before I have Owen come up here and make his statement, I do want to acknowledge that no one wins today, and I wouldn't want to be in your position today. I myself am deeply sorry for what has happened to the families that are here today. And nothing that happens here will ever make them whole, and it won't bring back their loved one.
All right. I think we need to take a break before we hear from Mr. Hines.
Okay.
So let's take a 10-minute break. The court will stand in recess until 3.
Okay.
Thank you.
All right.
Logistically, so there's no injunction order that we need to get right now, is that right? You know, we got that one done. Yeah. No. Release credit. PSR. Yeah. It's done. All right. After it's over. No, so we'll represent.
Right over. What size is your kidney now? Yeah, no, it's in the front. Your appendix is like lower right.
Well, there's
No, it's not. It's not lower. It's
as much as.
But I had almond milk.
Yeah, I'll get something. Let's, why don't we go in the
Right.
That's right, right? Yep.
Clear. Okay. Yes. I was thinking, how about we do this when it's done? Is it okay if the judge asks those first? Others, we have 5 minutes. I'm sorry, I'll put it. Yeah. You know what, that's right, yeah. So we will have hours leave first. Okay. Leave first. Perfect. Should we have the judge explain it to you? Yeah, maybe. Have the judge, okay, we'll ask to approach. Cool.
Yeah, we're ready.
I don't like the battery life on these.
Sure.
Yeah.
I know it seems like I take it home every night, but like it's dead.
Definitely. But like even you, like so I was plugged in all morning, I only have half. It died during my sentencing yesterday and I was like,
I keep getting this white
can never get mine to act right, so it won't load, and then it'll be like start over, and some other pop-up box happens.
All rise.
Thank you. Please be seated.
You can if you want, yeah.
Your Honor, may we approach briefly?
Yes. Okay, we are back on the record in CR 2004-006-528, 003, 006-240, 001, 105-048-001, and 105-174-003. These are all State of Arizona versus William Owen Hines. Record will reflect the presence of counsel. Mr. Hines is with us with his counsel as well. And families and victims are here as well. All right. Does Mr. Hines wish to be heard?
He does, yes.
Okay.
This year and a half has been very painful for everyone involved. There isn't one day that goes by that I don't think about that night. I saw the ambulance behind us as I was leaving and immediately knew something was wrong. I felt a lot in that moment. Despite being very intoxicated, I remembered everything. When I saw the news, I knew I needed to let somebody know my involvement. Though I was hesitant, though I knew I would do time, I knew undoubtedly that it was the right thing for me to do. I was not raised to tattle. I was raised to admit when I'm wrong, and I was definitely wrong. I'm here today to take full accountability for my wrongdoing and my own actions. I acted as a follower and not a leader, and that will now result in me doing time in ADOC. I should have learned from many past mistakes, but I was blinded and still am blinded by addiction and stubbornness. I should have asked for help, but the past is the past, and there is no way to change it. All I can do is move forward, better myself, and keep doing positive things. Alcohol was my way to cope for 3 years. The moment I drank that first drink and realized how much happier I felt, I was hooked. The pain of my first relationship issues on top of my grandpa dying in psychosis aftermath made life feel almost unbearable. The only thing I knew worked was party and drink. Little did I know I had so many resources I just didn't know how to ask. My friends and family have shown me that there is nothing wrong with asking for help when you need it. When I get to DOC, I'm going to apply myself. And once I finish my education, I'm going to do hands-on trade programs, as well as the available drug and mental health classes, so that once I get out, I can be a safe and productive member of the community and complete probation without issue. And for Ben, there was a very large chance that things could have played out differently on July 6, 2023. There's no explanation or excuse to make as to why I was driving with any percentage of alcohol in my system that night. For any nights, that is. The very thought of that alone is one of many that leave me sleepless during the night. I pray that recovery has been swift and that God will continue to take care of you and that you will still one day be able to do the things that you want to do to the fullest extent. Follow your dreams and never stop fighting. And for the Lord family, Although I did not know Preston personally, he seemed to be an astounding man, a kind soul senselessly taken from this world. He didn't deserve not one of those kicks or punches. This act of violence has now left a man without a son, a sister without a brother, and a father without his boy. I have realized it would be wrong to ask for forgiveness when this family has already had so much taken from them. They owe me nothing. However, I owe them everything. I am committed to discovering how I can better control the actions that I make and to continue to make the world around me a better place. I am truly very sorry. Thank you.
All right. All right. Any legal costs?
No, Judge.
All right. Thank you. All right. Folks, just a word about how the pronouncement of sentencing works. The court must consider aggravating factors, which the state has capably pointed out, and mitigating factors, which Mr. Hines's attorneys have capably pointed out as well. And the law has what we call presumptive sentences, and I consider aggravation and mitigation and decide where within a particular range available to the court the sentence should lie. When we speak in these terms, I realize that's not very comforting to you folks. And I wanted, before I do that, I did want to point out a couple things that struck me. Mr. Lord used the words tragic and senseless, and this, if ever there was a case that is tragic and senseless, this is it. I believe it was Ms. Golubovich who said no one wins in these kinds of cases, and that's entirely true. It's simply a matter of, sadly, trying to mitigate the losses that all you folks have experienced. So while what we do here today may not, let me put it this way. We use legal terminology, but it is my most sincere hope that what we do here today is the first step for all of you on the road to healing and finding peace with the terrible things, the tragic and senseless things that have happened. All right. Mr. Hines, in these four matters, back on March 4th, you pled guilty in each case. I believe the pleas were accepted at that time. If they were not, I'm accepting them now, and they are entered of record. Based on your guilty pleas in this case, or these cases, I should say, in the matter that ends in 528, it is the judgment of the court that you are guilty of count 2 as amended, manslaughter, a class 2 felony that is classified as dangerous and non-repetitive. That was committed on October 28, 2003. In the matter ending in 240, it is the judgment of the court that you are guilty of count 1, aggravated assault, a class 3 felony, committed on July 6, 2023, also classified as dangerous and non-repetitive. In the matter ending in 048, based on your guilty plea, it is the judgment of the court that you are guilty of count 2, aggravated assault, a class 6 designated felony, committed on November 22, 2022. It's classified as non-dangerous and non-repetitive under Arizona's sentencing code. And in the matter ending in 174003, it is the judgment of the court that you're guilty of count 2, aggravated assault, also a Class 6 designated felony, also non-dangerous and non-repetitive offense. In preparing for sentencing, the court has considered a number of things. And first, before I list those things, I want to thank the attorneys for their excellent advocacy in this matter. It was very, very well done, everything that I've received. I have, of course, reviewed the plea agreements and the agreements of the parties in there. I've reviewed the state sentencing recommendation to include the jail calls and videos that the state asked the court to consider. I've considered all of the victim statements, both here today and in writing. There have been two sentencing memoranda, mitigation memoranda submitted on behalf of Mr. Hines. I've considered those as well as, and those included some psychological testing and reports, as well as some thoughtful letters from Mr. Hines's family and friends. So I've considered all of that as well. All right, in two of these matters, and that's specifically the matters ending in 528 and the matter ending in 240, probation is not available, given that those are dangerous offenses, and certainly they're not. Probation would not be appropriate. In the other two cases, I will place Mr. Hines on probation, as that has been agreed upon, and I think it will provide him with some helpful structure upon his release from prison. I mentioned earlier the aggravating and mitigating circumstances. I'm going to focus on the manslaughter and the aggravated assault cases in terms of aggravators and mitigators. Certainly in the vehicular matter, there was a significant injury to the victim for Mr. Zizik, 4 months memory loss, traumatic brain injury. Thankfully probably doesn't even begin to cover it. Somewhat miraculously, he's made an excellent recovery so far, and it's my understanding his prognosis is good. Nonetheless, we are all lucky he's alive. And clearly that had an extraordinary impact on his family as well. In the manslaughter case, there have been a tremendous impact on Mr. Lord's family. The matter was done with accomplices as well. And again, substantial impact on the victim's family. There are a number of mitigating factors as well, which I will discuss. Your age at the time of these offenses is important. We do, the literature, medical literature tells us that a person's brain is not fully formed until they're 25 years old. And this is, and that helps explain a lot of bad decisions by youthful folks. So certainly your age is an important consideration here. You have, on a number of occasions, shown remorse, particularly right after the accident with Mr. Zizik. You were honest with the police, and you accepted responsibility in several respects. I like to think that I'm a really good mediator, and that I wish I could take credit for how well your settlement conference went. But the fact of the matter is that in many, many, many years on the bench, I don't know that I've seen someone more anxious to plead guilty and accept responsibility. So that certainly speaks well for your prospects. A couple of things that we haven't talked about that I think are worth discussing. A lot of educational difficulties that seemed that the schools weren't on top of, to some trauma within your family and from family members inflicted on you. You've also shown the ability to get employment at times, and you certainly have the support of your family. That's important because you will need it when you're released. Everyone does, but it's very important. So it's good to know that is there for you. I'll start with the aggravated assault case. So this is the matter, well, this is the dangerous. This is the matter ending in 240. As to that matter, well, before I do that, I did want to point out in the manslaughter case, it's a slightly different calculus because that did involve accomplices. It's important, I think, to point out that you were, what's been reported to me and the evidence available indicates that you were very much a lesser participant in that tragic and senseless outcome. So with respect to the aggravated assault, the court finds that with regard to that offense, the mitigating factors slightly outweigh the aggravating factors, and it is the judgment of the court that you be committed to the Department of Corrections for 5 years in that matter. And that is, as to that matter, you will receive credit for 441 days of time served. Turning to the manslaughter case, on this one was second in time, and it is a slightly different calculus. I find less mitigation there. There's still a lot of mitigation. But it's hard to give the same weight to the mitigation after all of these wake-up calls that you just did not, regrettably, you just did not act on. So with regard to the manslaughter, it is, and this is with regard to count 2 as amended in the matter ending in 528, it is the judgment of the court that you be sentenced to a term of 12 years in the Department of Corrections. That is slightly greater than the presumptive term, and that sentence will run consecutively to your sentence in the manslaughter case. All right, now I will turn to the other 2 cases. These are the probation matters. These are the matters that you're going to be on probation. Well, after you're released from prison, you'll be on probation. And as I said earlier, that it's important, it's good for you. There'll be plenty of services available for you. And we'll talk about some of that in terms of the terms of your probation.
I think it's only on the vehicular case right now, yeah. Yeah. Judge, real quick, I think I may have misheard, but the manslaughter sentence would be running consecutive to the aggravated assault
Correct.
sentence. Okay.
Correct. And I'm sorry if I misspoke. All right. So as to both of the probation matters, Mr. Hines, I'm giving you the standard supervised probation terms. There's a couple to keep in mind that I'll highlight. You're not to have any contact with the victims in any form. This almost goes without saying, but it will be a term of your probation. I will not consume or possess alcoholic beverages, and you shall complete substance abuse treatment, including relapse prevention and aftercare. So those are the terms that I'll highlight in both of the probation matters. And I will say, I've been at this for a long time, and I don't know that I can recall, and I was on a criminal assignment for 7 years before this case, and I don't know that I've ever seen anyone whose mental health problems are so profoundly affected by alcohol abuse and drug abuse. And we can debate the amount of insight you have into that. The state certainly debates it. I think you have some, but you got a long way to go. And so it's very important that you do whatever you can do in custody to get yourself ready when you're released, because you cannot drink. It's a miracle you're alive. It's a miracle Mr. Zizek is alive. Those aren't just terms of probation. That's going to be key for you just to survive, just to live any kind of normal life. So please do what you can, do everything you can, and then some. All right. There's financial aspects to all of these things as well. There's probation service fee of $65, $9 to the victim's compensation fund, $20 probation assessment, $20 time payment fee, $2 for victims' rights enforcement assessment, the criminal penalty assessment as well. And sir, with respect to your prison terms, I'm waiving community supervision, and you're going to be placed upon probation upon your release from prison pursuant to ARS 13603K. Where do things stand in terms of restitution?
So I believe at the moment, we would ask that you keep restitution open on the homicide case for a year and a half. I believe that there is not a request at this time for restitution in the vehicular case. I want to make sure.
Correct.
And then, although I don't believe it's going to come up, but maybe if you could keep restitution open on the 2 Class 6 cases just for maybe 6 months. And then, Judge, on the vehicular case ending in 6240, 2 housekeeping matters. By law, I believe his license has to be suspended. An abstract has to go over to MVD. And also there was a lifetime injunction, some paperwork that I believe was given to perhaps the clerk or one of the courts.
Thank you. And certainly it is so ordered, and we have, the clerk has prepared the paperwork for that injunction, which I will sign.
Judge, and I apologize if I didn't hear it. Did you give a number of years of probation on the 2 Class 6s?
It's going to be 3 years for each. Those will run concurrent to each other.
Understood. Thank you, Judge.
And Judge, if I may, for the restitution purposes, Owen would waive his presence at the future restitution hearing.
Okay.
Additionally, for the case ending in 240, which is the aggravated assault dangerous case, we will need to correct the pre-sentence incarceration credit. The PSR that's generated and calculates the dates, the end date is April 17th, 2025. We need to count until today. Well, not including today's date, Owen would have 456 days of credit.
Thank you for reminding me. It's actually correct on the computer. It was, my notes are from the PSR. So he will receive credit for 456 days.
Thank you.
You're very welcome. All right. It is ordered directing the clerk to send to the Arizona Department of Corrections the sentencing orders that I will sign shortly here, copies of all pre-sentence reports, medical and mental health reports prepared, as to Mr. Hines as well. Mr. Hines, I mentioned your probation terms. I did not cover all of them. I hit the highlights. but you're going to need to know them all, comply with them all. You'll get a copy of those before you leave here today. Please make sure you understand them and comply with them. Yeah, it's important for a lot of reasons, but if you violate your probation, you could be brought back into court and your probation could be revoked. You could get up to another 4 years in prison. Do well. We're holding restitution open for 18 months in the manslaughter case. Not at all in the Zizek matter, is that right?
In the Zizek matter, that's my understanding, Your Honor.
Okay. All right. And then we'll hold it open for 6 months in the other 2 matters. And we will note that Mr. Hines' presence is waived for any restitution hearing. Mr. Hines, you shall submit to DNA testing for law enforcement identification purposes. And on the motion of the state, the matters set forth in the various plea agreements for dismissal are ordered dismissed. It's also ordered exonerating any bond. Before you leave, Mr. Hines, you will receive a copy of your review rights. By pleading guilty, you waived your right to appeal, but you still have the right to petition the court for post-conviction relief and to have a lawyer represent you. If you cannot afford a lawyer, one will be appointed for you. If you cannot afford copies of the necessary records and transcripts, they will also be provided at no cost to you. If you wish to petition for post-conviction relief, you must file a notice within 90 days from today, or you lose the right to seek relief. And after you complete your sentence, you also have the right to ask the court to set aside the judgment of conviction in this matter. Before you leave the courtroom, our staff will have you sign something to acknowledge that you have been provided your post-conviction relief rights. You'll sign for your terms of probation as well, and you will be required to provide the court with a fingerprint, or the court staff, that is. We've covered an awful lot of ground. Is there anything else we need to address?
Not from the defense perspective.
Okay, Mr. Green?
Not from the state.
Okay, for the benefit of our staff, I wanted to, so that we can have an orderly procession out, I would appreciate it if the folks to my left would please exit first. And while Mr. Hines is signing some documents here, if you folks on the right, my right that is, will stay until these folks have departed. That way we don't have a stampede, and you folks can all, in an orderly way, get to your cars. I have some documents to sign, which I will do up here. To all, thank you, and again, I hope that this is an important step towards everyone healing. Thank you. We are adjourned. This one.
Oh, no, hit this one. Oh, this one there. Okay. Go. Oh. Don't worry about that. I added that consecutive.